Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and in this video I'm going to share with you 4 reasons why bankruptcy may be a very bad idea and more trouble than it's worth. But if this is your first time here to my YouTube channel, please click subscribe, check on that little bell, that way you'll be notified each and every week when I put out new videos that'll help you deal with your serious debt problem. All right, let's talk about bankruptcy. I am a bankruptcy attorney in the state of Arizona. Been doing this coming up on 20 years. And I can tell you after meeting with, I think one time I literally calculated I've met with well over 10 to 12,000 families and talked to them about their finances and trying to come up with solutions on how to deal with those problems. And I can tell you after filing many bankruptcies over the years, I have seen there are 4 categories or types of issues that pop up where bankruptcy may not be a very good option and may cause you a lot more stress than your debt's even causing you right now. So let's run through those. The first one where you can have some considerable problems if you're filing a Chapter 7 bankruptcy is if you have unprotected assets. What I mean by that is that in a Chapter 7 bankruptcy, the idea behind it is that it's going to get rid of all your unsecured debt, credit cards, medical bills, personal loans. All of those debts typically go away completely. They're discharged through that process. The trade-off is they assign a bankruptcy trustee to your case who's going to review the information that you submitted to the court and try and determine if you have any non-exempt assets. Non-exempt assets are assets that you owned free and clear that have values that are above and beyond what the law protects in your particular state. Those laws are called exemption laws. Most people have heard of the homestead exemption that protects homes. Well, there's exemption laws in Arizona for cars, for household goods, for firearms, for pets, retirement accounts, wedding rings, all those kind of things, to the point where most people who go through a Chapter 7 bankruptcy don't lose a whole lot. However, if you do have assets that are not protected by one of Arizona's exemption laws or the exemption laws in your state, you can run into a situation where the bankruptcy trustee will seize the asset, sell it, and give the money to your creditors. For example, let's say that you have a fishing boat that's completely paid for and it's worth $5,000. In Arizona, there is no exemption for fishing boats, and so if you file a Chapter 7 bankruptcy, the bankruptcy court will seize that asset, sell it, and give the money to your creditors. So it's important to know, if you're thinking of a Chapter 7 bankruptcy, to look at your asset situation and have a candid discussion with the bankruptcy attorney that you've hired so that you can kind of figure out what's at risk and what's not. Now, if you do have non-exempt assets, there may be ways to work through it with the bankruptcy trustee where deals can be reached as far as maybe you pay some money into the bankruptcy for distribution to your creditors and you get to keep the asset. That can be negotiated in certain circumstances. But if you have significant assets, particularly if you have liquid, like cash assets, cryptocurrency, those types of things, they'll likely be seized by the court and paid out to your creditors. So that's one scenario where a Chapter 7 bankruptcy in particular may cause you a lot of issues and maybe more trouble than it's worth. It is possible, and this is why I say always meet with your bankruptcy attorney and be completely candid about this. It may be possible that what you're worrying about is actually something that can be dealt with, or the alternative would be a Chapter 13 bankruptcy. Chapter 13 bankruptcy, you don't lose anything, you retain your assets. The trade-off is you're going to have to pay your creditors some money over a period of time before you get that final discharge order. The second area where bankruptcy may not be worth it if you have recently transferred assets out of your name. So for example, let's say that you had a vehicle, or let's say you had that boat that I was talking about, and you transferred your name off of the title and you gave it to your brother. Those types of transfers can cause you problems. Particularly in the bankruptcy court, they're going to look back over the last 2 years. And if you transferred any assets out of your name and did not receive money back that was reasonably equivalent to what it was worth, the court can consider that an improper transfer, and they can actually go back and undo that transaction. This happens in most instances innocently. Where I see it the very most is parents who are filing for bankruptcy. Their 16-year-old son or daughter got a car and it was in mom and dad's name. They turned 18 and then the title was just transferred over to them. Those situations can often be dealt with, or there may be solutions to them within the bankruptcy, but they're definitely something, again, that needs to be disclosed to your bankruptcy attorney before you jump in, and where the trustee can start wreaking havoc on that. Because if you did transfer something prior to bankruptcy with the hopes of protecting that asset, like I've had people come to me before and say, hey, I put my truck in my brother's name because I knew I was filing for bankruptcy and I didn't want that to be impacted. That actually will be. That'll be impacted. And so often we have to undo that and bring it back in and then deal with it and consider bankruptcy options. So my advice to people, if you're considering bankruptcy, status quo. Keep things as they are. Don't take your name off the title to anything. Don't sell anything without consulting with your bankruptcy attorney, because it is possible in certain situations to sell assets. You could sell that truck even to a family member as long as it's an actual transaction, you're actually receiving money back for it, and you're getting approximately what it's worth. Third area where problems can arise in a bankruptcy, particularly again a Chapter 7 bankruptcy, is if you have loans from family members or friends and you've been paying them back in the last 12 months. Those types of payments where you pay back a family member or friend in the 12 months prior to filing for bankruptcy are called preferences. Essentially, you're preferring your family members or your friends over your other creditors. If you're in that situation, the bankruptcy trustee again can come in and they can go back to your family member or friend and tell them they need to give back those any payments that you paid to them in the last 12 months. This will make Thanksgiving awkward forever. So again, as with the other two areas, often these things can be resolved, particularly if they're lower dollar amounts. You know, I've had clients come in and say, yeah, I paid back my mom, she loaned me $150. Things like that are generally not that big of a deal. If it's been thousands or tens of thousands of dollars though, that can be a bigger problem. You don't want to pay back family members or friends right prior to filing for bankruptcy. And if you have been making payments in the prior 12 months, you want to disclose that specifically to your attorney so that you can decide whether it's still okay to file your bankruptcy or whether you need to wait a year from the last time that that payment was made so that the preference issue does not become a gigantic issue in your case. All right, the fourth category of where you may want to avoid bankruptcy, this one is extremely rare. But if you have debts that were incurred through fraud, and we're talking not that you got into debt and couldn't pay it and now you need to file bankruptcy, we're talking Bernie Madoff, you're running some kind of pyramid scheme or something like that, where there's legitimate fraud. Like I said, I almost never ever see this. I've seen it literally a couple times in my career over the last 20 years, but there are instances where if you think that the debt was incurred through fraud or there were some bad actions on your part, bankruptcy is probably going to make that problem a whole lot worse, because now the creditors have a forum where they can come in and raise those objections. And not only that, the bankruptcy trustee who works for the Department of Justice, they will have a big old magnifying glass on everything that you're doing and everything that you've done in the past. You have to turn over documentation, information about finances, information about bank transfers, all that kind of stuff. And so if you've been in there, you may want to talk to another type of attorney or look for different ways to resolve your debt issues through a non-bankruptcy means. Now, those four areas are almost all specific to Chapter 7 bankruptcy. Sometimes people come to me and think, oh, this is going to be a huge problem, we're not going to be able to work through it, and it's a simple problem and we can get through it. There are other times where bankruptcy is just not going to be an option because of one of those four things that we talked about. But sometimes, like I mentioned before, a Chapter 13 bankruptcy is a better option if you have some of these issues, minus the fraud one. If you're committing fraud, you're going to have problems. But the other three, a Chapter 13 bankruptcy can resolve a lot of those issues so that it's not a big problem. You can still go forward, get the debt relief, keep your creditors at bay, and be able to get to some kind of resolution. Again, my name is John Skiba, and I am a bankruptcy attorney in the state of Arizona. My contact information is below. I'd be happy to help you. I do a free consult for Arizona residents only. Unfortunately, I'm only licensed here, where we can go over some of these things and kind of put together a plan on how to deal with that serious debt problem. Thanks for watching today.